Welcome to the Purchasing Division's Vendor Resource Module for Vendor Resolutions, Disputes, and Protests. The Purchasing Division developed this Vendor Resource Module series to assist any vendor who wishes to conduct business with the state of West Virginia to learn the state procurement process, as well as to highlight the vendor's responsibilities in this process. Should you have questions following this presentation, you may find additional information on the Purchasing Division's Vendor Resource Center. The link to this site will be provided at the end of this presentation. Let's get started. The state purchasing process begins with specifying in detail what commodity or service an agency needs. In turn, interested vendors offer a bid which meets or exceeds the specifications in the solicitation. Should a problem or situation arise affecting a participating party, in essence, the Purchasing Division, state agencies, or registered vendors, the Purchasing Division refers to established procedures to assist in the resolution of these issues. In this presentation, I will explain these established procedures, including the communication necessary between the agency and the vendor to resolve any issues. I will discuss the two types of vendor protests, those of bid specifications and those of purchase order or contract awards. And finally, I will provide in detail the purchasing director's authority to suspend a vendor's right and privilege to bid on state purchases. All vendors conducting business with the state of West Virginia are bound to the terms and conditions of the various contracts for which they are supplying commodities or performing services. These responsible vendors must be capable of producing the desired commodities or services while adhering to the established performance level or quality standards and delivering the prescribed quantity at the appropriate delivery rate. It is important that vendors clearly understand the requirements of the contract and their responsibilities to the outcome expectations. If an agency determines that the received commodities or services do not meet the specifications offered by the vendor, it is required to contact that vendor in an attempt to resolve any issues. The agency must provide the vendor with a description of the problem and the expectations of the outcome. The vendor should respond to the agency in a timely manner with clarification or possible solutions to the problem. If the agency's attempt to resolve the issue is ignored, or the agency and the vendor are unable to come to an agreement, the agency may resort to completing a vendor performance form detailing its complaint. The form, along with the appropriate documentation, is submitted to the Purchasing Division, which will respond to the complaint by contacting the vendor directly to resolve the issue. The vendor performance form is generally the agency's final attempt to resolve the problem. The Purchasing Division uses all substantial documentation relating to the complaint to determine the appropriate course of action. Vendors have the option of protesting certain decisions made by the Purchasing Division. A protest is an administrative remedy provided by the Code of State Rules that allows an entity to challenge contract specifications written by the agency or to challenge the ultimate contract award. A protest of specifications, as the name indicates, is an opportunity for the vendor to protest the specifications that were written prior to bids being opened and prior to the actual award being made. Protests based on bid specifications must be submitted no later than 5 working days prior to the bid opening. If a protest of specifications is received within 5 days of the bid opening date, the Purchasing Division can make no guarantees that it will consider the protest. If there is a flaw with the specifications, it is imperative to submit a protest during the allotted time prior to the bid opening date before vendors' prices are exposed. In these situations, it is much easier to deal with any deficiencies on the front end. A protest of specifications is intended to guard against an agency that intentionally or inadvertently drafts specifications that circumvent the requirement that competitive bids be obtained by including specifications that are so restrictive that only a small number of vendors or commodities can meet them, or by including specifications that are too vague, allowing vendors to provide a less than acceptable quality level commodity or service. The second type of protest is the protest of award. The protest of a contract award must be submitted no later than 5 working days after the award. This type of protest is the most common type received by the West Virginia Purchasing Division and involves an entity objecting to the award of the contract to a bidder. Reasons that protesters give for objecting to a contract award are varied, but some of the more common grounds given to the Purchasing Division include the winning vendor not being a resident vendor as claimed, the winning vendor bidding inferior commodities that are not equal, the winning vendor not having the required experience or the appropriate licenses, the winning vendor failing to meet a mandatory specification, sign a bid, or not including the purchasing affidavit, or the losing vendor being improperly disqualified, just to name a few. The vendor is responsible for knowing the bid opening and award dates. To aid in this process, the Purchasing Division faxes letters on the day of the award, notifying all bidders whether their bid was successful or unsuccessful. The Purchasing Director or his designee will review the matter of the protest and issue a written decision to the vendor. A hearing may be conducted at the option of the Purchasing Director or his designee. Additionally, the Purchasing Director, at his discretion, may decide to continue with or delay the award of the purchase order or contract. The Purchasing Division reserves the right to refuse to review any protest where the matter involved is the subject of litigation before a court of competent jurisdiction, has previously been decided on the merits by a court of competent jurisdiction, or has been decided in a previous protest by the Purchasing Division. The provisions of this subsection do not apply where the court requests, expects, or otherwise expresses interest in the decision of the state. Most protests are submitted to the Purchasing Division in the form of a letter. The protest must be in writing and include the name and address of the protester, the requisition, purchase order, or contract number associated with the protest, grounds for the protest, any supporting documentation, and the resolution sought. Failure to submit this information will be grounds for rejection of the protest. The name and address of the protester are required for any correspondence between the protester and the Purchasing Division regarding the matter. Without this information, the Purchasing Division would not know who to respond to, thus making the protest defunct. The purchase order number will assist the Purchasing Division in pulling the file for the exact contract the vendor is referring to, and will save time in the protest process. Next, the vendor's grounds for protest must explain to the Purchasing Division exactly what the issue with the contract award is. Any supporting documentation must be submitted as evidence verifying the vendor's grounds for protest. And finally, the vendor must state exactly what it is that the vendor hopes to come out of the protest. Most protests only require a review and written response from the Purchasing Division. The review generally includes an analysis of the protest letter, including the grounds given, a discussion among the Purchasing Director, the Assistant Director, the Purchasing Attorney, and the Purchasing Division buyer assisting in the acquisition to determine the protest's validity, a review of the relevant files, and sometimes input from the awarding agency. After the review process, the Purchasing Division will provide a written response to the vendor that 1. Rejects the protest as being improper, 2. Denies a relief requested with a short explanation as to why, or 3. Grants a relief requested. The most common forms of relief sought include cancellation of the current award, re-award to the protesting entity, or rebid of the solicitation. If the Purchasing Director determines that a protest has merit and remedial action may be required, the Director will issue a cease and desist letter that will halt all future use of the existing contract in question until a determination can be made. In some instances, a written response alone is not sufficient, and the Purchasing Director will require an administrative hearing, often referred to as a protest hearing, to resolve various issues set forth in the protest. Such hearings are at the discretion of the Purchasing Director and may last several hours or even days. The protest hearings are not formal court proceedings, but closely mirror such proceedings. A protest hearing will include witness testimony, cross-examination, and documentation that is presented to an administrative law judge for consideration. After the administrative law judge makes a determination based on the evidence presented, he or she will present the findings and a recommendation to the Purchasing Director. Very rarely, if ever, will the Purchasing Director deviate from the judge's recommendation. The Purchasing Director has the authority to suspend a vendor's right and privilege to bid on state purchases and place the vendor on the state's debarment list for a period not to exceed 1 year, when the Director has reason to believe that such vendor has violated any provisions of the purchasing law or the rules and regulations. The power and authority of suspension vested in the Purchasing Director may be exercised when there is a reason to believe that one of the following conditions exists. A vendor has exhibited poor performance in fulfilling its contractual obligations to the state in more than one purchase order or contract. A vendor has willingly breached any purchase order or contract entered into pursuant to the provisions of the Code or the purchasing regulations. A vendor has violated any provisions of the purchasing laws or regulations, or a vendor has been convicted of any federal, state, or local law punishable as a felony, which conviction arises from the vendor's acts or omissions directly related to the performance of the purchase order or contract. When the purchasing director has reason to believe that the provisions of the purchasing laws and regulations have been violated, the vendor will be notified by a certified letter containing the reason for such suspension. Any vendor notified of a suspension may request a hearing to be scheduled with the director. If the hearing confirms the suspension, the vendor may have the director's action reviewed by the Secretary of the Department of Administration. Should you have questions about the information covered in this vendor resource module, you may visit the Purchasing Division's Vendor Resource Center at the link on the screen in front of you. Additional information can be found in the Vendor Procurement Guide, also listed on the screen in front of you. Thank you for taking the time to view this Vendor Resolutions, Disputes, and Protests Vendor Resource Module.